Case is For Good Government et al. Versus the Davidson County Election Commission and the Metro Government of Nashville and Davidson County et al.
Good morning.
Morning.
Good morning.
We will start shortly with our opening statements. Before that, I have two matters that I need to cover, two preliminary matters. One relates to a notice that the plaintiffs had filed, it was on Friday, about bifurcating all of their count two, part of their complaint related to the constitutional claims. I've received notices from the other side, the Election Commission and also Metro, that they have no objection to that. So we will proceed with that part of it bifurcated, and it will be tried at a later time. We also had a motion to quash filed by Metro, and it was to quash the testimony, the oral testimony of Mr. Delanis of the Election Commission. I'm going to handle that, Mr. Roberts, is we'll take up the argument on that motion to quash at the time that you call Mr. Delanis. I'm assuming he's not your first witness. If he is, we'll go in and take that up, but we'll just wait to argue that until you call him. Do you know what order your witnesses will be called in?
Your Honor, I think I can address Section Mr. Delanis. I was surprised when Metro filed that notice. I had already spoken by email with Mr. Dean Koch earlier in the evening and said that we weren't going to call him because of the court's order on Friday. He was sort of a backup, and we had no intention of calling him because he went totally to the issues, the factual issues related to the civil rights violation. So we do not intend, and I was very surprised when I got Metro's motion. I probably should have included him in the email that I sent to Mr. Koch, but it didn't cross my mind to do that.
Okay, so you're not going to call Mr. Delanis as a witness, and the motion to quash then is moot?
Correct.
Good. All right.
Your Honor, I should clarify that that was not Metro's motion. Metro has not filed a motion with respect to Jim Delanis's testimony at all. I believe that was the Election Commission's motion.
Was it the Election Commission's motion?
Yes, Your Honor, it was, and we filed it, I believe it was Friday.
Okay, good. All right, so it's moot, and thank you, Ms. Bussell, for that clarification. Okay, those are the preliminary matters that the court needed to address. At this time, we will start with the opening statements. Mr. Roberts, if you would proceed on behalf of the plaintiffs.
Thank you, Your Honor. And I wasn't certain when reading the court's prior order whether you were going to address our motion to dismiss. We did file a supplement to that motion over the weekend.
Yes, let me tell you how I'm going to handle that, Mr. Roberts. I'm going to rule on the motions to dismiss along with the rest of the case at the end of the case. I saw your supplemental motion to dismiss. I see what it asserts, but I still need more information. The supplemental motion to dismiss says that a final decision was not made by the Election Commission. There are some facts involved in that. I need to hear the facts. So all the motions to dismiss will be decided by the court at the conclusion of the case with the other issues. Does that clear that up?
Yes, Your Honor.
Okay, very good. All right, let's go. Yes.
Your Honor, I apologize for interjecting. We have not been served with any supplement to a response to a motion to dismiss filed by the plaintiffs, and I would ask that we be served with that so that we can be prepared to address that.
We'll get that to you. Mr. Roberts, at the next break, if you would let the person who assists you in your office know that for some reason Metro did not get that. Mr. Seaman, it is posted on the court's electronic docket system, so Ms. Bussell, you could look at it that way. It is on there if you want to get somebody started on it. But
Chancellor, I apologize. It may not. Actually, that one I don't believe is posted yet. I got a notification by Clerk and Master Ms. Solis this morning that there was a little error in the queue. We were having some issues with that. So I can get a copy or he can email a copy. I don't know if it's technically gotten through the filing yet, but.
Okay. All right. So it may not have been in the filings. I've looked at it. And Mr. Roberts, you need to serve that on Metro. Okay.
And they need to serve it on the commission as well. We haven't received it either.
Okay. If you will do that as well.
Okay. And Your Honor, one other thing I would say, Mr. Domini, who's going to be our first witness, but who's also a plaintiff in the case, I had him not sign on to the Zoom conference, but he's in the room with me. I think that's appropriate because it is a party, but I just wanted to in case he says something, I didn't want anybody to think that we were.
Okay. Yes, he is allowed to be present in the room with you since he's a party. All right. Are we ready to begin now with our opening statements? Good. We got these preliminary matters cleared up. You may proceed, Mr. Roberts.
Thank you, Your Honor. This is a very important case, and it is an intentional case. And I think there are some very critical issues here. I know the court is going to wait to hear some evidence on the motion to dismiss, but the court is going to hear evidence. And I think many of these documents are stipulated to, so it's not much, I would say, controversial in the sense that the ballot petition was sent out, signatures were gathered, they were turned in, they were verified. Yes, there were several versions of the petition. They were mailed out versions, there were downloadable versions, but the content, the actual amendments are being requested to be placed on the ballot are all the same. And there's no dispute about that part. Only there is some discussion about what they call the preamble, whether that was the same, well, based on the different forms. The problem we have, or I should say, the problem that the Election Commission or perhaps Metro has is that the requirements for ballot initiative are spelled out in section 1901 of the charter. And they're very, very simple and very, very clear. And they only require the citizens to put forth a petition and gather a certain number of signatures. There are no other requirements. And a lot of the opposition to this ballot initiative seems to stem from this idea that because they don't like the ballot initiative, they can graft on a litany of other requirements or nitpick the ballot initiative for what it does or doesn't do. But the bottom line is what the citizens wanted, they wrote down, they signed, and they turned in. There are many other states and other cities that have very complex ballot initiative processes. There are other, if we were in other areas, that law might be radically different. And I've studied this involved in some term limit litigation I was involved in years ago. And many of these ballot systems have time limits, for example, and they have subject limits and caption limits and a lot of different limits. But the truth is we don't have that. And so I think it's going to be very difficult for the Metro or the Election Commission to say this ballot petition didn't comply with the form when the form is spelled out. The people relied upon the form as it was spelled out, and they complied with that form. And so nitpicking, and that's the only word I can think to call it, about whether there's a caption or whether the language is inflammatory. We disagree with that characterization, but we also don't really care because there's nothing in the charter that says you couldn't have an inflammatory amendment. We certainly don't think it is, but this ballot initiative was designed to do certain things. And those things were made very clear in this ballot initiative. And every bit of that was intentional. And so they have a choice. Once that's done, once the ballot initiative and the first couple of documents, Your Honor, are pretty much stipulated to, they're with signatures were turned in, where the Metropolitan Clerk sent the ballot initiatives, the petitions over to the Election Commission, where the Election Commission verified the signatures, and the clerk acknowledged that. I mean, no one disputes that. And from that point on is where this case evolved. All of that was done by about September 17th. And on September 17th, things began to go into motion. And at that point, there was an Election Commission meeting held on September 25th. And two very interesting things came out of that. And part of this will come from the transcripts of that meeting, which are also stipulated too. We don't have any minutes which we can rely upon. And as the court knows, often the boards and commissions speak through their minutes. We don't have those. So all we really have is the transcripts. But the transcripts are very illuminating. The transcripts are going to show that the Election Commission didn't do anything. And this has been sort of our problem from day one. And this is part of our supplement on the motion to dismiss, is that they didn't take any affirmative action. This court's going to hear about the city of Memphis versus Shelby County ad nauseum. That is the seminal case that starts all this. And so let's just get that on the table. But it's not the only case. And that case is very strong in its language about the Election Commission's functions being ministerial. And as pointed out by Mr. Delanus at the meeting and is in our supplement, there are two cases that follow that. And they talk about the Election Commission can't just have purely ministerial. They're not a machine. They have to think at some point. We grasp that. But that thinking is limited to two very specific areas. Did the petition comply with the form? And there's several cases on the form. And those forms talk about required number of signatures. Those form talks about whether they have the right caption. They cite some other states' cases where they go to those technical details that were required by the statute. Well, we don't have any form requirements. And so on its face, each one of those petitions clearly says these amendments. It lists out a thing below of amendments. And then right below it, it says this amendment shall be voted on a certain date. We submit that there is no ambiguity, there is no uncertainty or lack of clarity. That it's disingenuous to try to misread a ballot petition that way. And so we submit, Your Honor, that the form, I don't think this court's going to have any difficulty determining that we've met the form requirements. And part of Metro's objection, I'll just go ahead and pull the sting on this, is to say that other ballot initiatives have been done differently. Your Honor, we'll concede that. I was involved in two ballot initiatives 12 years ago. And the one that I did, it was one I did personally. I basically copied what other people had done. Mr. Crafton copied what other people had done. There is a long history of people copying what other people had done when it comes to ballot petitions. What there's not is a requirement that they copy it. So the ballot petition on its face meets the requirements. But what is the only other option that the Election Commission, only discretion, I should say, that the Election Commission is going to have is to say that it is facially unconstitutional. And I spent most of the weekend researching facially constitutional. I've come to the conclusion it's a lot like pornography. You sort of know it when you see it. There doesn't seem to be a very clear-cut standard. What we know is what facially unconstitutional is not. First, it is not a substantive unconstitutionality. It is not an analysis of the constitutionality that takes facts and determination and in-depth research. It has to be facial. And so that substantive is not part of what their discretion is. And the reason, I should back up a second. The reason that's important, Your Honor, is this is about timing. Why are we here today? We're here because a mandamus was filed to force the Election Commission to put the ballot initiative on the ballot. In response to that, there has been claims made that the ballot initiative should not go on the ballot. And the city of Memphis is very clear. There are certain types of claims that are made pre-election, and there are certain types of claims that are made post-election. And the logic and rationale behind that are pretty clear. Ballot initiatives may never be approved. 12 years ago, Eric Crafton did an English first ballot initiative. And while I'm constantly accused of being a part of that, I was not part of that. I never met Mr. Crafton until he came into my office and said, hey, I want to get this on the ballot. And that was entirely my legal aspect. But the question of that is very serious. Should he have been allowed to place that on the ballot? And we litigated the same issues that we're litigating right now. And it was allowed on the ballot because it didn't violate the Constitution. And then it lost. It lost hugely. It never came to pass. And the litigation to be involved never came to pass. And this court doesn't have jurisdiction over matters that may never come to pass. That's an advisory opinion. And it's just not right. And so there is a carve out. That's the best way to call it, a carve out of the ripeness requirement that says if a ballot initiative is improper in form or facially unconstitutional, then and only then does the court have a right to, or does the Election Commission have a right to make some sort of determination. That same restriction applies to the court. And so so we have to look at this on a pure level of facial unconstitutionality. And what is troubling about the pleadings from Metro and Election Commission is they seem to really want to throw the kitchen sink at this and try to bring up every possible complaint that they might have from here to the end of the universe of what might go wrong with this ballot initiative, all these scare stories of what might happen. Well, those are not relevant to this court's analysis. This court has to look at this as well under the premise that it is either facially constitutional or facially unconstitutional. That being said, the burden then shifts to Metro. They have the duty of coming forward, or the Election Commission, or excuse me, yeah, use those together, have the burden of coming forward and showing it's facially unconstitutional. They are going to be required, Your Honor, to show you a section of the Constitution and say, this is facially unconstitutional. And what that means is that not only does it might even appear unconstitutional, but that there are no set of facts, no possible way it could ever be constitutional. And that's a pretty high burden. And there's nothing in their pleadings that support that. What the Election Commission and Metro do is continuously go back and talk about state law, the local government ordinances, Metro charter ordinances, all these different things that are completely irrelevant to this analysis. Those fights come later, and they will come later, I'm sure. But today we're fighting over whether it's facially unconstitutional. And that is the limited authority that they have. When we look at ballot initiatives, or excuse me, I should say look at legislation in general, there is a very strong presumption that when the legislature acts, that it acts in a constitutional matter. That's a pretty black letter concept of law. It has to happen. There has to be deference to the legislature. Interesting. And we cite half a dozen cases on that very issue. But when you get to ballot initiatives, there's even a better standard, or I should say even a higher standard, because they're even more protected. And we cite several different cases on that. One of them says when there is a vote of the people, the presumption of favorability must prevail. That comes from the Jordan versus Knox case. And that Jordan versus Knox is a great case, Your Honor, because it shows how the court shows even greater deference to the desires of the people than the legislature. And in Knox County, to sort of sum it up, there was a ballot initiative that was too broad, that attempted to place term limits on state offices, which it just couldn't do, clearly not allowed to do. And so the court interpreted the ballot initiative to be that the expression of the people wanted the term limits to apply to the extent possible. And so instead of striking down that term limits, it said, well, surely they meant it for just about the offices that it would apply to. And so they looked for any possible way to allow it to be. And it was in Jordan that they said if a provision can be legitimately construed in a variety of ways, it is the court's duty to adopt a construction that will sustain the statute and avoid that constitutional conflict. That needs to be how this court looks at this. So they are going to attack the 5 different versions of this, 5 different sections of this ballot initiative, and they're going to have to show how each one of them violates the Constitution on a facially basis. If they cannot do that, then this simply is not ripe for adjudication and should be dismissed forthright. It is odd that in doing this research, only 2 years ago, we had another ballot initiative. In fact, the reason this ballot initiative is not set on the November election is because there was one 2 years ago on the November election, and there was litigation involved in that. And it is ironic that the position, as we point this out in our trial brief, that the Metro Legal's position in that litigation was that there was no harm in having the public go ahead. I'm quoting from their brief. There is no harm in having the public go ahead and vote on the referendum now that the election process has begun. The Court of Appeals even expressed some surprise at this, that they were so willing to allow this election to go forward, but it was Metro's position that it could just be invalidated later. Contrast to this case, where they're doing everything they can to stop it, presumably because they think it can't be done later. So that's how as I see this court looking at this case, they're going to have to show. Now, there's 5 different provisions. Here's an example: the tax, rolling back the tax. There is no provision in the Constitution that says that a local entity cannot restrict the way that taxes are levied. No doubt that the Tennessee Constitution grants the legislature authority to grant taxes. There's no dispute about that, or to enact taxes. But there's nothing in the Constitution that prohibits it. And we all know from Tennessee Constitution says that all power is inherent. It's not delegated to the state, it's inherent in the people. And so the Constitution itself supports the people's actions at any time, that it's not specifically restricted. So from a facial challenge, there is nothing in the Tennessee Constitution that prohibits it. The legislature then delegates to the cities, but we're not here to discuss violations of state law. Not yet, anyway. We're here to deal with the Constitution. But even if we look at the state law, Your Honor, there are still that delegation to the council, to the metropolitan government, gave it the power to enact taxes. And that power comes through the charter, and that charter can be amended. And as even pointed out in the Commissioner Cooper's memorandum of law, there are attorney general opinions that clearly state that the 2003 opinion clearly states that the people have the ability to affect taxation by referendum. So it's not clear that it's unconstitutional. It can't be clear it's unconstitutional because it's not unconstitutional, but it's certainly not facially unconstitutional. And so there is no constitutional flaw with that provision. Each one of those provisions, Your Honor, has an effect on the metropolitan government, or if passed, would have an effect on it, but it would have to be passed. And until it is passed, those issues are not ripe. And that's why these issues, I mean, sort of circular, are just simply not ripe for adjudication. All of the complaints, all of the brickbats are meaningless unless they can point to a specific provision. Part of the reason we filed this motion to dismiss, Your Honor, is that I'd like this court to keep in mind as we go through this, is that we don't really have a ballot initiative even before this court. What I mean by that is we had a meeting on September 25th. And at that meeting, in fact, Commissioner Delanis actually proposed that the ballot initiative be voted on, that they excise one section of it that he didn't think we had complied with. And it had to do with a signature requirement as to the limitations on bonds. You have to have a certain number of signatures, and I will concede that we did not have a sufficient number of signatures under state law to meet that requirement. That requirement's not in the Constitution, but even I'll concede that we didn't have it by state law. There was doesn't matter. And so Mr. Delanis suggested that the ballot petition be approved with that language taken out. He could not even get a second on his motion. And so the commission took no action. The only action it did take relevant to this petition is it voted to conditionally reset the date to December 15th. The problem with that conditional setting is that it is not self-effectuating. There is nothing to create that date unless the Election Commission takes action. It voted on September 25th to file an expedited lawsuit to have a judicial determination. And then it didn't do anything for 2 weeks. And the transcripts clearly show that there was communication going on long before September 25th with the Metro Department of Law. They didn't file suit, and they sat for 2 weeks. The reason we waited 2 weeks, Your Honor, is because we felt like the deadline for the commission to act was we're going to get to a point that they had to act by a certain date. And then before that date, we wouldn't really have standing. They would have had an opportunity to come in and fix the problem. And so we sort of had to wait to see what was going to happen. We filed on October 8th, which is Thursday. And on Friday, 2 weeks after they had voted to file an expeditious lawsuit, they finally filed suit. 3 days after that, on Tuesday the next week, Metro filed a 700-something page complaint. They clearly, Your Honor, had gone to the trouble to draft complaints, to get ready to file a complaint, but had never taken any action. I'd like this court to think about what would happen had they never taken any action. If we had not filed a lawsuit, they would have never done anything, or I submit that they would have never done anything. They wouldn't have taken any action. and the ballot petition would have never got on the ballot. And so we have this problem that there really isn't an action by the Election Commission that this court could even review because it didn't do anything. The cases that came after City of Memphis that are relevant are the Littlefield case, which Mr. Delane has talked about, and the McFarland case. And both those cases are very, very clear and very, very strong that the Election Commission was not just entitled to, but had to make a final determination before there could be judicial review. And some of Mr. Delane's comments are quite interesting because he keeps telling the commission, you're going to have to make a decision. You're going to have to go into court and say, this is what we want. You're going to have to tell your lawyers, our lawyers, he said, what we want. This court doesn't know what we know what the lawyers for the Election Commission want, but there's not even a witness prepared to testify as to what the commission wants in this case today. In fact, our attempts to get an Election Commission representative in this court were violently opposed by the other side. We asked for a designate of the commission. We were quashed. We asked for Mr. Delanis to be a witness. They fought that. They did not want someone to come in and tell this court what they wanted. So we're stuck with that. A reading of the transcript shows nothing has happened for this ballot petition. So as part of our motion to dismiss, Your Honor, we believe that the Election Commissions and the Metro's cases should be dismissed entirely on the basis of ripeness. As soon as this court comes, if this court comes to the conclusion that this case is not ripe, it should be dismissed. Now, that does not mean our mandamus is dismissed because we're asking this court to force the Election Commission to do something. If we look at the McFarland case, and I don't just say that idly, the McFarland case says a trial court may not have jurisdiction to hear an issue otherwise reserved for a county election commission until the commission issues a final determination. I'm asking this court to order the Election Commission today to notice up a meeting for Wednesday with 48 hours notice and to make a decision. They very well might decide to put 4 out of the 5, excise the bond. The bond issue is the one that seems to be most contentious. They might decide, as Mr. Delanis had recommended, to put those 4 issues on the ballot, which would eliminate an entire trial on that issue. They may decide to put the entire thing on the ballot, or they may decide to put none of it on the ballot. We don't know, Your Honor, and you don't know what they're going to do.
Let me ask you this question, Mr. Roberts, and I'll be quick because I know you've got only about 10 more minutes. The petitions that the voters signed contained all of those 5 provisions, and there was no severability statement in there. Under those circumstances, what it would appear is that the voters, the folks who signed the petition, is that they wanted all of those matters to be part of the referendum. So how does the Election Commission or this court have the authority to excise, take out one of the provisions when the petitioners signed all of that as a package, so to speak? And if you take that out, then you are, I guess, disrupting, presuming, corrupting what the petitioners asked to be put on the ballot.
We are, and that's a great question. In fact, I've asked that question about 100 times to myself in thinking of what I'm going to say to you. The court decision would come after the Election Commission's decision. I would submit that the Election Commission.
So you would refer me to the case you did before, I think it was the Jordan case from Knoxville, where the court then said, okay, I'm going to just apply this to the offices that would be affected. So while the court might have the power, how would the Election Commission have the power to strike one of those provisions?
I'm not sure that truthfully, that's a settled legal issue, that no election has attempted to do it. I have, Mr. Delanis argued, and truthfully, Mr. Delanis somewhat convinced me. He's a fine lawyer, and I listened to his legal arguments, and I was somewhat impressed with him in that from a
you've given me your answer, and I don't want to take up your time, but there is no there is no precedent for that. And you've argued that the Election Commission has very narrow discretion, and you've argued that they cannot look into the substance of a constitutional issue. And this appears to be that it would be the substance of determining what the, petitioners intended. So you don't have any authority for that proposition one way or the other, but you assert that they do have that discretion. That's the side you land on.
Well, there's two issues. One, what Mr. Delana said was that when we look at the form, and that is one area that they have authority, there is a deficient number of signatures for that one provision. And so they could argue, I think credibly, to say, well, these 5 things were what they wanted, but they missed the form on that one thing. And so therefore we have the authority to excise that. No court has litigated that. And that seemed, I think, a rational solution. I would look also to the legislature. Tennessee law has a provision in it that very clearly says, while severability is not sort of favored, Tennessee statute clearly says that there's the authority to do that. If the law is passed and it doesn't have a severability clause and it can be severed without damaging it, then that's preferred.
And we know that the charter, the Metro Charter, it's not required to follow that state law. That state law that you cited just applies to the Constitution, et cetera. However, you would say that Metro should use that as guidance in this situation, and the court should use it. Okay.
I think that analogy is also, taken with the Jordan case, where you're looking at interpreting what the people wanted. And what the people wanted was these 5 things. Would the people be satisfied if only 4 got on there? I would say yes. That they are distinct. They're not linked together in a way that they build on each other, like you might see in a severability issue in a statute. They really are 4 different things. If that were to be done, if the court were to order the Election Commission to make a decision, and they made that decision, then we would have to make a decision whether we wanted to challenge it, and then Metro would have the authority to challenge the other 4 that went on the ballot. We would know what we were litigating over. And that's my concern here, is that there's nothing to create an election except for this court telling the Election Commission to do it. And we would submit that this court at this point doesn't have the authority to tell them what to do. You tell them to do in the sense to put it on the ballot, but what to do with the ballot. That's our big concern on that.
So you've got about 5 more minutes, and as I understand it, your position is that the court should dismiss the claims of the other parties, grant your claim for the mandamus, and order the Election Commission to make a decision about whether to put this on the ballot and how to put it on the ballot. Is that the relief that you're seeking from this court?
Your Honor, I think it's the only relief the court can grant. So yes, if at that point they make a decision, then the fight may continue and it may not. I mean, that is, again, fundamentally in this fight, Your Honor, is what's a pre-election versus a post-election challenge. And neither the Election Commission nor this court are really allowed to litigate issues that may never come to pass, because they may get voted down. And if it's voted down, then everything we're doing is a waste of judicial resources. And that threshold, so that very limited ability to adjudicate prior to the vote, is narrowly construed and has to be in very specific circumstances. And I submit, Your Honor, that we don't know what the Election Commission is going to do. That I think and I cite this in our memorandum and our supplement, the Commissioner Hertzfield's motion, which was approved by the commission, was to ask the court what its duty was. And I would submit that that's not what this court should do. It's not this court's, and I mean duty, not in legal duty, but factual duty. And that this court.
One final question, Mr. Roberts, and it's along the same lines of the severability issue that you and I were talking about. The election code, the Tennessee code annotated election code that you said we should look to for guidance, it provides that the code was enacted to secure the freedom and the purity of the ballot. And certainly that would be the job of the Election Commission in this case, to assure the purity of the ballot. When I looked at the petitions that have been filed, they contained bolding and some other marks that I would call in the vernacular marketing. I want to emphasize certain points, marketing a point of view by using bolding. Is that something that can just be severed, or is it so systemic? Is it so necessary for these provisions that the Election Commission does not have the discretion to take that out? And if it is marketing, then it's not a pure ballot. It's not a neutral one. It's advocating a point of view. It's not putting it to the voters neutrally. Quick response to that, and then we'll have to close your time out.
I would submit that the changes to the font size, bolding, that type of thing was certainly within the purview. They prepare the ballot. I took those, what I would call captions, and I don't think there's anything inappropriate about having a caption to a legislative section, either in a state law or in a metropolitan ordinance or in a referendum. I don't think advocacy words are inappropriate. If they were, there would be something in the charter prohibiting those. We are advocating for a certain position. Every law advocates for a certain position. That's why many metro bills have recitals at the beginning of them saying what their goal is and what they're attempting to do. Those recitals
That's not really advocacy. That may be a summary for the voter, but this is marketing when you're bolding, highlighting something, drawing someone's attention. It's not neutral, it's not pure. So you understand the question, and you've told me they can take that off. You think they have the discretion to take that off?
I would think the font size and the bolding and stuff is certainly within their purview, Your Honor, but the language was intended to be there. That's a good example. If the Election Commission decides to excise that and put it on the ballot anyway, then we would have to make a decision whether, or I guess I would, and it troubles me to make a decision for 27,000 people, but I sort of feel like I have to. I would have to make a decision what the next step would be. But I don't think they have that authority. But we are in such uncharted waters that Mr. Delane has somewhat convinced me that he was right. I'm not sure I like that as a precedent, to be honest, but at least made sense. Who knows what a court would say? That's the problem, though, Your Honor, is that we are in a lot of uncharted water, and the deference here is to the people. 1,000 people took the time to sign their name to a petition. I get petitions in every single day. I got about 15 on Friday. Still want it. This is what the people wanted. They have a mechanism in their government that allows them to petition the government. We submit there is nothing in this petition that is facially unconstitutional. And if there is something that's violated state law, then that's a litigation we'll have on November 6th or December 16th. But the question is, what are we fighting about today? And I don't think this is an appropriate mechanism to do so. I understand Metro not being happy about it. I get it. It wasn't intended to make them happy. It was intended to restrain the metropolitan government. And they clearly have that authority. They are exercising that authority, and they're entitled to it. As it relates, even though we're not going to deal with the civil rights issues, the civil rights issues are paramount. The First Amendment does allow you to engage yourself in the political process. This is not just about the 27,000 people that signed the petition, but it's really about the 450,000 people who get to vote on the petition. And many of these people will vote no, I'm sure, no doubt. And they will be sending a political message. They will be exercising their First Amendment right to vote, to send a message to their governmental leaders that they want certain things to happen. And a number will vote yes, hopefully a majority, but they will be sending a message. And that participation in the political process should not be truncated at this stage because of what might happen in the future, absent a clear facially violation of the Constitution. And if there's any way for this court to say, well, maybe it's unconstitutional in this way, but it's not in this way, it should do that, and it should allow it to go forward when that time comes. Thank you.
Thank you, Mr. Roberts. At this time, the court will hear the opening statement of the Election Commission. After that, we'll take a short break, and we will hear opening statement from Metro. All right, let's proceed with the Election Commission's opening statement.
Thank you, Your Honor. I appreciate it. Before I begin, may I make two quick points?
Yes.
First point regards Mr. Roberts' concern about undue delay in our filing suit. And I'm obligated to tell the court that soon after September the 25th, I communicated with Mr. Roberts that we were proceeding to file our petition. He told me that he had finished a long trial. Your Honor knows what that trial was. And he was going on vacation and would not be in the office. And I wrote back and told him, out of deference to his time off, that we would delay filing our petition till he was back. So that's the reason for that delay. The second point I'd like to make is that while we're perfectly prepared to get into the detailed discussion of the legal arguments this morning, I have not been favored with a copy of Mr. Roberts' trial brief. I don't believe the city has either. So
and neither has the court, and neither has the court. I did not have it this morning. I had Mr. Seaman check while we were going through the opening statement, and I do not have it as well. And it was a matter that I was going to bring up when we concluded the opening statements. I assumed it had been filed with the court, but I thought perhaps it had been served on opposing counsel. All right.
No, Your Honor, the Davidson County Election Commission is a bipartisan body charged by state law and the Metro Charter to conduct orderly elections. The Election Commission is before the court today to defend its actions in this case, to seek judicial guidance regarding the scope of its authority with regard to this petition to amend the Metro Charter. We do not have a ballot initiative here. We have a petition to amend the Metro Charter. To ask the court to determine whether the defects in form or facial and procedure legality asserted by Metro are sufficient to prevent placing this petition on the ballot. And then finally, to ask the court to address the significant substantive constitutional issues regarding this petition that have been raised by the metropolitan government. We concede that those substantive constitutional issues are beyond the power of the commission to address. But permit me to be clear, the Election Commission has not and is not suing the residents of Davidson County who filed this petition in good faith. They didn't draft this petition. The Election Commission's focus is exclusively on the legal adequacy of Mr. Roberts' petition, a petition he says has been 10 years in the making. I confess to being somewhat puzzled about the injury that the plaintiffs claim to have suffered. If they are claiming that they are being deprived of their opportunity to vote on this petition, they are factually mistaken because the proof will show that the Election Commission has conditionally set the election for December 15th. And as far as the commission is concerned, there is no dispute that there will be an election on that date if ordered by this court and not stayed either by this court or the appellate court. That leaves only the claim that they have somehow been harmed because the election will be held on December 15th rather than December 5th. It will be difficult for them to demonstrate how a difference of 10 days amounts to a legal injury, particularly in light of the Election Commission's statutory authority to select the election date. During this hearing, Your Honor, you will be presented with two starkly different versions of the process for filing petitions to amend the Metro Charter and the role that the Election Commission plays. Mr. Roberts has told you and will continue to tell you that the Election Commission is essentially a rubber stamp. When a petition to amend the Metro Charter is filed, the Election Commission's only role is to count the signatures, and if there are sufficient signatures to hold an election on the precise date he has requested. The evidence will show that this election will cost the taxpayers approximately $800,000. In Mr. Roberts' world, if he could convince enough registered voters in Davidson County to sign a petition to amend the Metro Charter to limit the eligibility to run for mayor to only men, the Election Commission would be required to hold an $800,000 election to vote on a charter amendment that violates the Equal Protection Clause on its face. In addition, if he picks Christmas Day for the date of the election, then the Election Commission would be required to hold the election on Christmas Day. Following Mr. Roberts' approach would demean the process, waste $800,000, frustrate the voters, and require the taxpayers to underwrite the legal expenses for the lawsuits that would inevitably be filed following the election. The Election Commission has a different view of the process. First, Mr. Roberts does not have the legal authority to dictate when the election will be held. Tennessee Code Annotated 2-3-204A gives the commission the discretion to set the date for an election between 75 and 90 days after being directed to hold one. The proof will show that the Election Commission, acting consistently with its discretion under Tennessee Code Annotated 2-3-204A, has conditionally set the election for December 15th. Second, the commission does not agree that it is a rubber stamp ministerial body. Our position is aligned with the Supreme Court's 2007 opinion in McFarland versus Pemberton. In that opinion, the court stated that election commissions, quote, in performing their statutory duties, perform both ministerial and discretionary functions. And the court went further to point out in McFarland that election commissions even have implied discretionary functions. The Elections Commission is also consistent with the Tennessee Supreme Court's 2004 opinion in City of Memphis versus Shelby County Election Commission. There, the court stated that election commissions may consider deficiencies in form or facial or procedural legality when deciding whether to place the petition on the ballot. Neither the state charter nor the Metro charter provide guardrails to guide the Election Commission in carrying out its discretionary duties. Accordingly, the election commissions have looked to the courts for guidance. One of the reasons why the Election Commission is seeking declaratory relief here is that Tennessee courts have not yet provided clear guidance regarding the scope of Election Commission's authority to review deficiencies in form or facial or procedural legality. Another reason is that the Election Commission is mindful that the Tennessee Supreme Court's clear holding in City of Memphis versus Shelby County Election Commission is that election commissions cannot address questions regarding substantive constitutionality of a petition. Metro has raised substantial questions regarding the substantive constitutionality of Mr. Roberts' petition, and the commission is respectfully asking this court to address those questions. The commission's posture in this case is similar to the posture of the Shelby County Election Commission in 1987, when a dispute arose over filling the vacant clerk position for the Shelby County Juvenile Court. The juvenile court judge insisted that he could fill the vacancy without an election, while the state election coordinator and the attorney general took the position that the vacancy must be filled by an election. Rather than picking sides, the Shelby County Election Commission decided to file an action for a declaratory judgment before an election in the Chancery Court for Shelby County. And when the Tennessee Supreme Court handed down its opinion in Shelby County Election Commission versus Turner in 1988, it held that the Election Commission had standing to pursue its declaratory judgment action before the election. Because of the importance and expense of holding elections to amend the Metro Charter, the Election Commission is adopting what is essentially a measure twice and cut once approach. Resolving significant issues regarding the legal sufficiency of Mr. Roberts' petition before an election is, in the Elections Commission's opinion, conservative and appropriate. As best I can tell, even Mr. Roberts agrees that the necessarily adverseness among the parties exists. However, he continues to insist that the legal adequacy of his petition should be addressed after the election, and then only if the voters approve his amendment to the Metro Charter. The Election Commission does not agree and has briefed this issue extensively in its trial brief. We believe that this dispute has matured to the point that it warrants judicial decision. If the court orders it, an election on Mr. Roberts' proposed amendment will be held on December 15th, 2020, unless this order is stayed by another court or this court. If an election is held, the proof will show that the election will cost as much as $800,000. Mr. Roberts' proposed amendment to the Metro Charter is self-executing. No other action by Metro will be required, and it will go into effect immediately. Because of the retroactive nature of several of the petition's provisions, the passage of the referendum will immediately cast a cloud on Metro's ability to collect the 2020 property taxes, on the bonds that Metro has already issued in 2020, and on Metro's contracts with professional sports teams. Simply adding the language of Mr. Roberts' amendment to the Metro Charter will also create internal conflicts in the Charter itself, which will promote controversy and litigation for the foreseeable future. Mr. Roberts and Metro have fully briefed the substantive constitutional issues raised by this petition, and only the courts can address those issues. Accordingly, the Election Commission respectfully requests this court to find that the decision is ripe for review prior to holding an election, to determine whether the defects in form or facial or procedural legality raised by Metro are among the matters that can be considered by election commissions under the City of Memphis versus Shelby County Election Commission. Then exercise your equitable authority to determine whether, in fact, the defects in form or facial or procedural legality raised by Metro are sufficient to disqualify Mr. Roberts' petition from being placed on the ballot. And finally, to exercise your judicial power to address Metro's challenges to the substantive constitutionality of Mr. Roberts' petition. The Election Commission respectfully submits that at the conclusion of this hearing, the evidence and the law will support a decision that the Commission has not violated Section 1901 of the Metropolitan Charter, and that for good government's request for a writ of mandamus and for an injunction should be denied. Thank you.
A few questions, Dean Koch. I want to make sure that I understand the Election Commission's position vis-a-vis Metro. It appears to the court that the Election Commission's position is they are here rightfully before the court, that it is ripe, and that you want the court to then make a determination about whether this referendum should be placed on the ballot. Do I understand that the Election Commission takes no position and is not going to make recommendations, suggestions, or give the court any guidance on what the scope of their discretion is? You said in your opening statement that it's an open question in Tennessee, that we don't have clear guidance on the scope of the Election Commission's discretion. Is that going to be provided to me by the Election Commission and what they think that should be, or is it just for me to make that determination?
Your Honor, as Mr. Roberts says, we are in uncharted waters here on many of these questions. The Election Commission, as prior election commissions in the past, when found in this situation, have asked the courts for guidance. We're hoping that Your Honor will provide some clear direction on what issues of form and what issues of facial and procedural legality commissions can address. We will be delighted to respond to any of questions Your Honor has with regard to our lawyers' answer to your question, but the commission, because it does not know that answer, has no formal position on how far its discretion goes. If it did, it would have acted. As Mr. Roberts has pointed out, the commission on the 25th first discussed changing the petition and passing it. That was not satisfactory to the body. They discussed denying the entire petition. That was not satisfactory to the entire body. And so the final decision that the commission made was to conditionally set an election and ask for your honor's guidance. And that's where we are.
So for instance, the Election Commission doesn't take any position on the severability issue that I questioned Mr. Roberts about. If the court, it's up to me to make a determination whether things can be severed out. That's what the Election Commission wants me to do, correct? They are not taking any position.
On that particular point, I believe that our brief points out first that when that was brought up on the 25th of September, Mr. Roberts forcefully informed the commission that he opposed severability, that there could be absolutely no change in the language, and that his input on that point, I think, certainly influenced the trial court or the commission's decision about that. Secondly, we pointed out in our brief, as you've already mentioned this morning, the statutory severability provision in the Tennessee Code applies only to the Tennessee Code. It does not apply here. And as Your Honor well knows, the questions of severability all hinge on the intent of the drafter of the language. And the clear intent we have voiced by Mr. Roberts himself on the 25th is that there can be no change in the petition. And there is certainly no language in the petition itself that would lead either the commission or the court to find that there was any intention on the part of the taxpayers to take a half a loaf on their petition.
All right. Okay, thank you, Dean Koch. The court was going to take a break, but let's go on. And we've got enough time now for me to hear the opening statement of Metro. So let's proceed with that.
Yes, Your Honor. Allison Bussell on behalf of the Metropolitan Government. Chaos and confusion. These are two outcomes that this court can and should avoid by concluding before a special election is held that For Good Government's proposed charter amendment is defective in form and facially unconstitutional. Over the next couple of days, we will present proof, mostly certified documentary evidence, showing the extensive damage that this proposed amendment will cause on Metro government relations, fiscal and otherwise. This evidence is important because, as the proof will show, not only is this petition atypical and so poorly drafted that we don't even know where it belongs in the Metro Charter, but it seeks to accomplish by referendum myriad actions that cannot be accomplished in that manner. We will talk about how all 5 provisions of the proposed amendment create unique and destructive outcomes, usurping the authority of the state, usurping the authority of the Metro Council, and seeking to turn legitimate and critical government operations into a popularity contest. Government operations such as generating tax revenue and issuing bonds to fund capital projects. Voter referendum is simply not available for every issue that might affect the electorate. And it's not available for much of what For Good Government seeks to accomplish here. Now, before I dive into the evidence that Your Honor can expect to hear, I should note that this trial will be pretty atypical, as I'm sure you figured out already. We aren't asking the court to do a lot of fact-finding based on witness testimony. Instead, we're going to present a lot of documentary evidence that we will ask the court to review alongside state and local law. This is necessary because all 5 provisions of the proposed amendment significantly impact current, future, and past government actions. That state and local law that we will refer to provides the framework for how the Metro government does business. And we need that baseline of how things normally work so that we can understand how the proposed amendment would change that. Let's start by taking a look at the petitions. Now, For Good Government submitted to the clerk 7 different petition forms. Only the first 6 are at issue here. Those 6 petitions outline what For Good Government is calling the Nashville Taxpayer Protection Act. It's important to note that there is no indication on any of those petitions, nor in the act or the proposed amendment itself, as to whether those petition signers wanted all of the proposed amendment or nothing. Or were the petition signers okay with provision 1 going on a ballot if provisions 2 through 5 could not? The simple answer to that is we don't know. The petitions were signed by 10% of individuals who cast votes in the previous election, not 10% of all registered voters. That's important, and I'll come back to that in just a moment. I want to share my screen, and I'm going to have the court take a look at some slides that I've put together that will allow us to kind of walk through these provisions. As the court can see here, there were actually 2 different versions of the introductory language that follows the title Nashville Taxpayer Protection Act. The first version starts with Nashville was flat broke before the COVID-19 crisis and goes on, as Your Honor recognizes, to advocate for why this proposed amendment should be, or why the petition signers should sign off. The second version, which is on the next slide, starts with repeal the 34% property tax increase and make Metro more fiscally responsible. Now, after that introductory language, there's another sentence describing that what the petition voters want to go on the ballot are these 5 individual provisions that follow, 5 provisions with 5 separate checkboxes. Now, before we dig into each provision, I'd like to take a moment to contrast this petition with other petitions that have been submitted. Now, contrary to plaintiff's assertion, we aren't suggesting that a petition must be in this precise format to satisfy the requirements under the Metro Charter. The point of this evidence is to show that these petitions made clear to the voters and to the Metro and to the Election Commission as to exactly what was being proposed. It's clear enough that the Election Commission could know what to put on the ballot, and clear enough that the voters knew what they were signing off on. So here on the left, we see a proposed referendum to change the Metro Council size and set term limits. To the right, we see the Save the Fairgrounds petition, which Your Honor is fully familiar with. In all of these examples, they make very clear what part of the Metro Charter is being amended and exactly what language is going to be substituted for pre-existing language or supplemented onto the end of existing language. Your Honor, this is how petitions are submitted for referendum election. Metro and the voters knew exactly how these proposed amendments purported to change the charter and exactly where they fit into the charter. Against that backdrop, the issue before this court is whether the Election Commission should place the proposed amendment on the ballot for a special election in December. And more specifically, the issue is whether these 5 provisions are defective in form or facially unconstitutional. Plaintiff's counsel just conceded in his opening statement that City of Memphis, it's what we all need to be looking at. And this is what City of Memphis says. Pre-election challenges to the form or facial constitutional validity of referendum measures are ripe for judicial scrutiny. Period. End of sentence. City of Memphis also cites the Burnell case. And the Burnell case tells us that pre-election interference with initiative and referendum measures on the alleged basis of substantive defects, those are prohibited. But at the same time, what is permitted is early determination of issues concerning both whether the procedural requirements for placing a measure on the ballot have been satisfied. That's those technical procedural requirements we've always been talking about. And secondly, whether a measure conforms to the applicable subject matter restrictions. That's what our evidence is going to show, that this referendum is being used to address subject matter in the wrong way, in ways that are prohibited by state law, in ways that are prohibited by the Metro Charter. Plaintiff, in fact, conceded in his opening statement that the court can look at form. And he also conceded that the bond provision, which I'm going to talk about in just a moment, fails to conform with the form of bond referendums under state law. So I'm next going to walk through each provision and just give the court a quick roadmap of the evidence that we intend to introduce that is relevant to each provision. And Your Honor, I would just submit that this evidence, these are not scare stories, as the plaintiff called them in opening, of what may happen. This is evidence of what will happen. It's also evidence, some of which has already happened. So let's walk through that. I'm going to start with bonds. It's the trickiest for most of us, and it probably will take the most time. This is what the bond provision says. Any bonds issued or guaranteed after January 2020, so that's 10 months ago, exceeding $15 million for a specific project, and then there are some exclusions in the parentheses, must be approved by voter referendum. Now, in the bond context, one of those state laws that we're going to ask the court to consider is the Local Government Public Obligations Act. And it's actually exactly what it says. It outlines the framework for what the government must do when it is issuing bonds. It's the right way to issue bonds under state law. This act, at the very outset, tells us the following. It is the intent and purpose of this chapter to create a uniform and comprehensive statutory framework authorizing the local government to issue bonds, to issue bond anticipation notes, to issue tax anticipation notes. The comprehensive statutory framework. If you want to issue bonds, this is how you do it. That's what the LGPOA gives us. Now, the metropolitan government issues two different types of bonds under the LGPOA, and that provision I just showed, Your Honor, actually references both of those. We issue general obligation bonds, and we issue what are called revenue bonds. Now, bonds can't be issued until after something that's called the initial resolution is adopted. That also is required by the LGPOA, and it gives Metro the authority to issue bonds at some date in the future. That initial resolution also gives Metro the authority to issue what are called bond anticipation notes, also referenced in that LGPOA subsection that I referenced a moment ago. Bond anticipation notes are short-term notes that are used to fund capital expenses. That note is evidence of an agreement that Metro will pay off that note at some point in the future by issuing bonds. We are going to introduce, as Your Honor can see on this slide, I've sort of outlined each of the pieces of evidence. We are going to introduce a couple of examples of those bond anticipation notes that were issued some years ago. Now, state law requires an initial resolution before those notes can be issued. And the LGPOA builds into this process a voter protest period. The implication of that is that when bond anticipation notes are issued, Metro is representing to those note holders that it has complied with state law, that it has complied with all the preconditions before issuing those notes. Preconditions like that initial resolution, preconditions like that voter protest requirement. These notes, Metro's representations, and the note holders' reliance on those representations creates a contractual arrangement between Metro and the note holders. And this is all outlined in the LGPOA. Now, once Metro is ready to pay off those bond anticipation notes, it adopts a bond resolution through the City Council and issues bonds to pay off the notes. We will also introduce an example of such a bond resolution, but not just any bond resolution. The 2020 Water and Sewer Bond Resolution that was adopted in March of this year during the time frame covered by this issuance of bonds provision. This document will show that Metro was authorized at a date in the future to issue $330 million in water and sewer revenue bonds. So again, over that $15 million threshold outlined in the proposed amendment. After that bond resolution is adopted, Metro issues the bonds, and it does so pursuant to what is called a bond purchase agreement with underwriters. We will also introduce an example of one of those purchase agreements. In fact, we will introduce the bond purchase agreement that accompanied that bond resolution in March. That document will show you that in April of 2020, Metro issued $245 million in water and sewer revenue bonds. So again, the issuance of bond provision would apply to both of these documents. One, they were both adopted after January 2020, and the revenue bonds that were issued pursuant to that bond resolution exceed that $15 million threshold. The General Assembly has already outlined the comprehensive structure for how bonds are to be issued, and this amendment does not follow that form. The LGPOA also requires a new petition to be filed every time bonds are issued by referendum. See, the LGPOA permits bonds to be issued by referendum, but not all bonds. In fact, the LGPOA says revenue bonds cannot be issued by referendum. So despite these requirements, the issuance of bonds provision would automatically require a referendum for every bond issue that exceeded $15 million without requiring a new petition. And it would require a referendum. In fact, it already requires a referendum for the water and sewer revenue bonds that have already been issued, despite the fact that those types of bonds cannot be issued by referendum. And then finally, the LGPOA requires a petition for a petition for referendum for the issuance of bonds to be signed by 10% of all registered voters. This petition was only signed by 10% of the people who voted in the last election. Again, plaintiff concedes in his opening statement that they failed to meet that form requirement under the LGPOA. The bottom line is this, Your Honor, this provision, which covers bonds issued 10 months ago, would automatically subject those 2020 revenue bonds that were already issued to a referendum, despite the fact that they've been issued, agreements have already been executed concerning those bonds, and state law did not permit those bonds to be issued by referendum at all. Next, let's talk about the tax provision. This provision says that property tax rates shall not increase more than 2% after January 1st, 2020, without a voter referendum. So any property tax rate increase after that date must go to referendum if it's more than 2%. Now, as a reminder, the referendum petition states that the property tax provision would, quote, repeal the 34% property tax increase, and it will repeal it now. That was the stated intent in that preamble that Mr. Roberts was referring to. Now, we will introduce several pieces of evidence to show the impact of this provision. First, we're going to introduce the mayor's budget book for this fiscal year, the 2020 to 2021 fiscal year. And that will give us a couple of pieces of information. First, it will show that the mayor's proposed tax increase would have generated approximately $332 million in property tax revenue. That budget book will also establish that, that the rate the mayor was proposing was $4.155 on every $100 of assessed property. That's important because we're also going to show you that what the council adopted, which will establish through the property tax ordinance, that property rate adopted by the council was actually 4.221, so greater than what the mayor proposed in the budget book. And then we're also going to introduce the 2019 property tax ordinance. And here's why that matters. This provision, which requires voter referendum, only kicks in if a property tax rate increase is greater than 2%. So when we compare that 2019 ordinance to the 2020 ordinance, we see that that increase was greater than 2%, which makes this provision applicable. The bottom line is this. This provision will do exactly what it purports to do. It will repeal an existing property tax ordinance by referendum, which the Metro Charter does not permit. Now, state law authorizes property tax bills with the new property tax rate to be issued in October of every year. This means that the proposed amendment will effectively repeal an existing tax rate established by a duly adopted ordinance after the fiscal year has already begun. Not only is this a completely impractical way to do business, but it also violates state law.
Let me return you for just a moment on the difference between repeal and amend. What is the difference in this circumstance that you've described to the court? Why have you characterized it as a repeal as opposed to an amend? What's the difference there? Well, the difference would be, for one, the petition signer's stated intent was to repeal that property tax ordinance by making it retroactively apply. So also, just the wording tells us repeal. Is there anything more? Absolutely, Your Honor. So the second one is state law. State law makes very clear that the property tax rate cannot be amended, whether we want to call it amendment or repeal. All right. State law makes clear that that cannot be done mid-fiscal year. Yes, now I understand, yes, what the substance is in those words of amend and repeal. Okay, thank you. The other important point to be made here, and Your Honors reminded me of it, is the Metro Charter does not permit repeal of an ordinance by referendum at all. In fact, the Metro Charter prohibits ordinances from being adopted or repealed by referendum. The charter permits charter amendments by referendum, but not ordinance amendments or repeal. So this is another way in which they are attempting to use the referendum process to do something to address a subject matter that is not permitted by law. So again, Your Honor, just to wrap this piece up, the mayor's proposed budget recommended a tax increase lower than what the council ultimately adopted. And the estimate from the mayor's budget book was $332 million in in property tax revenue to be generated from that increase. What this tells us is that $332 million estimate is low compared to what actually would be generated by this increase. That means if this amendment is put on a ballot, the Metro government will lose more than $332 million in property tax revenue for this fiscal year that has already begun. All right, let's take a look at the failed promises slide. And these will go a little quicker, Your Honor. So the failed promises provision is about sports. And if a professional sports team leaves Nashville or doesn't play games for more than 2 years, then all of the commercial development surrounding that team reverts to the people. And all of the contracts surrounding that team are also terminated.
Now, we will introduce a couple of different types of agreements that are relevant to this provision. So the first is an agreement called an Intergovernmental Project Agreement. These are agreements that are entered into between the Metro government and the Sports Authority that basically outline the terms for financing and construction of the property, whether it be land or buildings, that will be used for the professional sports teams. Many of those agreements involve a transfer of property from Metro to the authority. And many of them also contemplate that the Sports Authority will later enter into a lease agreement with the sports team for those facilities and the property. And that's exactly what happens from a practical perspective. The second document we will introduce are some examples of lease agreements between the Sports Authority and the professional sports teams that play in our city. Agreements relating, for example, to the Titans Stadium, to Bridgestone Arena where the Predators play, to the ballpark where the Sounds play, and to the soon-to-be constructed MLS soccer facility. These teams have lease interests in these facilities through these contractual arrangements. They also have property interests in related commercial endeavors in the general area. All of these agreements, existing agreements, will be terminated if this provision kicks in, and all of the property at issue will revert back to the people. Now let's take a look at the no giveaway provision. This provision requires a voter referendum for all transfers of interest in real property that is valued over $5 million and leases that exceed 20 years and commence after January 1, 2020. We will introduce into evidence a Metro Council approved ordinance that authorized a lease agreement between Metro Schools and Belmont University. That lease agreement was entered into this year, has a 30-year term, and it involves the construction and use of athletic facilities. Despite the school board approving that lease, the Metro government approving that lease, and Belmont approving that lease, this amendment would attach a new burden onto that lease, the burden of a voter referendum, months after the parties reached their agreement and signed on the dotted line. The same is also true for the lease agreement between Walsh Management and the Sports Authority concerning the MLS soccer facility, and the ground lease between the Fair Board and the Sports Authority. Both of those documents were entered into in 2020 and have terms exceeding 20 years. Finally, let's take a look at the public records provision. What does it do? It says that public instrumentalities under Title VII that receive more than $250,000 are bound by this agreement, and it effectively alters state law on how public records should be addressed, and says that anyone receiving that amount of money from the government, should they fail to provide public records, will be liable for treble damages and attorney's fees. We're going to introduce evidence that shows from the budget ordinance that both the Sports Authority and the Hospital Authority receive more than that amount and therefore would be affected by this provision. All right, let's wrap up, Your Honor. We've covered all 5 provisions and the way that they will completely alter how the Metro government does business. These are business operations that in most instances are not pulled out of thin air. Instead, we do business this way because it's required by law. Laws that set forth the guardrails on how government can and should operate. But for good government wants us to ignore the guardrails that dictate what referendum is available for and how it should be done.